Assalamualaikum and good afternoon, students.
Afternoon, madam.
Okay, good. So everyone is okay. Everyone fine today?
Fine, madam.
Okay, okay. Come on, got children's voice there. So for today's class, we will finish up prerogative of management. That's the last topic, termination and retrenchment. Okay. So it's very relevant during COVID. Okay, so I will introduce to the student what is actually retrenchment and what are the procedures that the employer have to follow before they can terminate and retrench the employees. Okay. Okay, so we start with termination. So I think from the previous class, you know that termination is like you're going to resign from your employment. So it can be resignation, it can be retirement. Okay, and if it is from the employee's part, so we call it retirement or resignation. Okay, and on the other side, the employer also can terminate the employee. So the employer can terminate for poor performance or maybe for misconduct, or he can also retrench the employee, or he can also it's stated there again, terminate for poor performance. Okay, so we will study about dismissal or misconduct later, but for today's class it will be on retrenchment. Okay, so redundancy happen when there's a retrenchment. Okay, so in case of redundancy, the employee's post is redundant. That means the contract of service is terminated. Okay, so what is actually redundancy? Or redundancy happen first, then only you will retrench the employee. Okay, so redundancy refers to a surplus of labor as a result of reorganization of a business. Okay, or it can be also reduction in production, merger, takeover, or it can be because of economic turndown or others. Again, nowadays we got problem of termination of employees because of COVID. Okay, because of COVID, employers, they have to reorganize the business. Okay, like if they're a big company, they will reduce the scale for the business so that they will profit and they will not bear the losses, not so much. Okay, and maybe because of COVID, they got a reduction in production. Okay, maybe there can be a takeover or merge with other companies, like banks. They can merge together, like two banks merge, and they can form a new bank. Okay, so this is how actually redundancy happens. So it's a surplus of labor. Okay, so when you say surplus of labor, that means it's too much of a manpower. Okay, like a company have 100 employees. Okay, so because there's a economic turndown. Okay, now the company only need 75 employees. Okay, they got 100 employees, now they need only like 50 maybe, or maybe 75 employees. So they actually facing surplus of labor. That means there's more manpower than what the organization or the company needs. Okay, so it's a surplus. It's more than the needs of the company. Okay, that's why we call redundancy is a surplus of labor. Okay, why? So it can happen on because of many reasons. Okay, can be because of reorganization, reduction in production, merger, takeover, economic turndown, or others. Others can be so many things. Okay, so retrenchment. Okay, retrenchment does not include if the employee resign voluntarily or on his own will. That means he resign. Okay, it does not. It doesn't mean retrenchment. Okay, the employee retire, also not it cannot be said retrenchment, okay? Or where there's a termination of employment for a fixed term. Fixed term is only that you are employed for 10 years or 5 years. Is after that particular fixed term is over, the employee's contract with the employee is terminated. So it does not include retrenchment. Okay, or it can be because of the employee's conduct, any willful conduct, okay, or maybe the employee is terminated because of illness or any disease, okay, or is because of misconduct itself, okay. So it is all these categories or example is not retrenchment, okay. So retrenchment must happen, okay, as a result of surplus of labor, okay. And it can be it can be from these reasons that mentioned in slide number 3. Okay, so can an employer retrench his employee? Okay, so because of COVID, maybe everybody knows that maybe like even the shopping complex, they not many people going to the shopping complex, so they don't need so many sales girl there. Okay, so the mall decided to reduce the number of the employee. Okay, so can the employer do that? Okay, so according to Cycle Carriage Bintang Berhad, the court says that retrenchment of employee can be justified if carried out for profitability. That means the company have to reduce because the company want to make profit, or for the economic purpose, or for the convenience of the employer's business. Okay, that means economy or convenience is all because of the company's goal to make profit. Okay, so the service of the employee may well become surplus if there is a reduction, diminution, or cessation of the type of work the employee was performing. Okay, so the court says that the employer, of course, can reduce the number of the employee, okay, because he want to make sure that he got profit, or for his convenient purpose, or for the economic purpose. Okay, and because of that, okay, the service of the employee will become surplus. Okay, surplus means more than what has been needed. Okay, that means the type of work the employee was performing will be reduced or diminished or can be ceased. Okay, so can you all understand actually what is a retrenchment now? Okay, can you all
Yes, madam.
understand? Can, okay. Um, like who's Yi Chin? Where are you staying, Yi Chin?
At home.
Yeah, in which state?
Penang, Penang.
Penang. So, are there any mall been closed, or maybe hotel been closed that you know?
Yeah, there are some shop that have been closed, like for
Mm-hmm.
drinks instant.
Mm-hmm. Okay. So if it is closed, that means it's totally all the employee will be retrenched. So, but if it is like some hotel, they reduce the number of employee, like like airline, okay, Malindo, or maybe Asia, they reduce the number of employees. Okay, so it's also retrench. It's either you retrench all the employees because you are not making any more profit, or you want to make sure that you are still running with some profit, you want to reduce the number of employees, you can do so. Okay, so the employer are allowed to retrench the employees, but they must have reason. Okay, so you will see, we continue to see who have the burden actually. Okay, so you can it is like that. If the employee been retrenched, of course, the service contract will be terminated. Okay, then the service of the employee will be redundant. Okay, so who have the burden actually? Okay, of course, where the employer reduce the number of the employee and he doing for the convenience and also to make profit, of course, the burden is on him. Okay, the employer have to prove actual redundancy. That means there's surplus of labor. Okay, say that okay, the business is not good, so he now need only maybe 50 employee. Okay, his company got 70, so he need only 50, or maybe he have to reduce to half. Just like 30 employees, he say is enough during COVID time, maybe. Okay, so whatever the employer do, he must do it with bona fide. That means with good intention. Okay, so the burden according to Malaysian shipyard case. Okay, the burden of proof is on the employer. Okay, so whatever according to the law, the facts that you mentioned, you must support with cases. So this case says that the burden is on the employer to prove with evidence. That means you must have evidence that redundancy is real. It's really happening in your company. Okay, and the decision to retrench a particular employee or maybe 10 employee or number of employee that you have already identified is not mala fide, okay, or agitated with victimization. That means you do not choose the particular employee because you do not like the employee, or maybe because that any other factor. You cannot victimize the employee. Okay, you must go according to the procedure how you want to select the employee. So we will see later. Okay, how you want to choose who will be retrenched or terminated. Okay. So for that, we actually do not have one legal definition on what is retrenchment or what is redundancy. Okay, but we will follow the code for industrial harmony, which was introduced. Okay, to achieve greater industrial harmony. Okay, so this code is not only for retrenchment, but all matters regarding industrial harmony. Okay, so the case or the court have also given statutory recognition for this code. Okay, there's a general provision in section 30, subsection 5A of the industrial relation. The word relation is missing here. Industrial Relation Act, and also in several cases regarding this code. Okay. So for the code, we call clause or article. Okay, so you can use the word article or clause when you refer to a code. But when you refer to act, okay, like Employment Act, Industrial Relation Act, you mention section. Okay, so this code emphasize on clause 20 to 24, emphasize on redundancy. That means it's surplus of labor. Because there's surplus of labor, you have to retrench them. Retrench means you want to terminate them. Okay, this is a special word that you use when there's a redundancy. You want to terminate because of redundancy. You said that the employee been retrenched. Okay, it's not a proper word to use termination, but normally we say retrenchment. Okay. So clause 20 it says that in circumstances where redundancy is likely, an employer should take positive steps to minimize the workforce by adoption of appropriate measures. Okay, so the employer, he's doing business, so he knows that maybe because of COVID, okay, he say, okay, now many countries are facing the same problem with on COVID. Okay, so less people go to work. Okay, let's say the company is producing men shirt. Okay, so less people are going to work, so we do not use what you call like shirts going to workplace. So it's very lenient that employees allow employee to work from home. So the what you call the purchase for the men clothes are become very less, or the demand for the men's clothes are become very is already coming less. Okay, so the company says that okay, we cannot produce so much, we have to reduce the number of production. Okay, so we have to reduce work. Okay, so employees must be, the number of employees must be terminated. Okay, so the employer here must take positive steps. So he knows that redundancy is likely. He can foresee that he have to reduce the number or minimize the number of the workforce. Okay, because less demand, so he have to produce less production. So he do not need so many employees, so you have to reduce the number. Okay, so employers, they can foresee, because they are doing business. Say, okay, last month or maybe in January they got maybe 50 or maybe 500 orders. Okay, when it comes to February, it's already like 300. Then when it comes to March, okay, less and coming very is reducing. Okay, so the employer have to stop recruiting new employees. So the employer do not need new employees, because the one that in the company is over or is already surplus. Okay, and he also do not need to give overtime. Okay, less production, why you want to give overtime? Okay, and you can also reduce the weekly rest day and public holiday. Okay, sorry, you can limit the work on rest day. Okay, that means maybe you give overtime. Okay, now you do not give overtime, and you can limit the work on rest day. Okay, public holiday is a no overtime, no work. Okay, and then reduce the number of working days. Okay, that means maybe one week your employees are working 6 days, you want to reduce to 4 days, or if they are working 5 days, you want to reduce to 4 days or 3 days. It's up to the employer. Okay, that he don't want to close the business, but he want to the business going on. Okay, and he can also reduce the daily working hours. Like, let's say, okay, the working hours is like 8 hours, he can reduce to 5 hours. He can do so. Okay, and then he also can conduct training program for the workers. He knows that maybe 50 workers will be retrenched or 20 workers be retrenched, so he give training to the workers so that they can find work somewhere else. Okay, so that is under clause 20. Yeah. Okay, so clause 20 also, okay, says that the employer have to identify alternative job and transfer workers to other division. Okay, he know that retrenchment is likely, so he can do so. Okay, or implement temporary layoff. Okay, there is a shutdown of the companies with fair salary. Okay, so employer during retrenchment, he can reduce the salary and assist the employee. Okay, obtaining temporary employment anywhere else. Okay, until the company resume to normal, or introduce pay cut. Now this one is fair salary, this is pay cut, is a different. Okay, this will be the last resort after other cost cutting measures has been carried out. Okay, so everything is in clause 20. Okay, it's very long. Okay, now clause 21. Okay, clause 21 says that the employer have the right, he have the responsibility to decide on the size of the workforce. Okay, of course, you are running the business, so the law give you enough freedom to decide the size of the workforce. So you know what is the demand for your production. Okay, so you will decide how many orders you will make, so how many workforce you need. Okay, so whatever you do, okay, the employer do, he must consult, okay, with the employee's representative or their trade union. Okay, so the steps I mentioned is clause 20. So many steps that we see before, okay, in the previous slide, must be done after consultation. So the employer cannot, even though he have the prerogative, he cannot do it himself. He cannot take his own decision, but he have to consult the employees representative, and where companies have their trade union, with the trade union representative. Okay, so the employer must discuss and also negotiate with the trade union or the representative. Okay, so that is under clause 21. Okay, so clause 22 says that, okay, um if the retrenchment become necessary, so the employer cannot avoid, okay, after he have reduced the overtime, maybe less working days, okay, and also other measures that mentioned in clause 20, okay, he said that he must retrench the employee, okay, so he must take the following steps. Okay, so he must warn the workers that the particular employee who has been chosen will be retrenched or terminated. Okay, so it's very important because employees, they do not want to lose their job. Okay, so if you choose a particular employee to be terminated, okay, you must make sure that you inform the employee so that the employee is aware that he will be terminated um, within which period, maybe in 2 months' time or maybe 6 months' time, the employee will take his own precaution. Okay, then the employer also can introduce voluntary retrenchment or retirement, okay, with some payment. Okay, sometimes we as a voluntary separation scheme, or where they get a compensation because the employee was retrenched. Okay, so some employees like that, no? Because they say, okay, I'm already 50 now, I better accept whatever the company give me as a compensation, because I'm already tired, or maybe my children can support me. Okay, so some employees like to accept the retrenchment benefit. Okay, then employers also have to retire the employee who have beyond their normal retirement age. Sometimes, company got employees like 67 or 70 years old. So those are who are beyond their normal retiring age. Now retiring age is 60. So the employer also can retire them first. Okay. Then the employer must also work with the ministry, okay, Ministry of Human Resource, okay, to find work outside the undertaking. This is sometimes difficult during COVID. It's not easy. Okay. Then spread the termination period over a long time. That means you do not terminate or retrench the employee at the same time. Maybe first month two, the next month two, like that. So you go according to a longer period. Okay, you do not terminate it at one time. Okay, then you also have to make announcement, but the announcement can only be made after the workers, okay, or the trade union are informed. That means you do not put in the media saying that, like Asia we saw, okay, the or maybe Malindo, okay, Malindo says that they're going to retrench employees. So you do not make announcement in the newspaper until and unless you inform your own workers first or their trade union. Okay, because it's very sensitive issue. Okay, no one want to lose their job. Okay, so any question now on the code? Can you understand the code? So for code, we do not refer many clauses, just clause 20 to 22. That means three clauses, 20, 21, and 22. Okay. So any question, students?
No, so far, madam.
Okay, so you can understand. Okay, so this topic is very relevant because if you see maybe your relative been retrenched, okay, you can explain to them, the employer have duty, okay, what are the duties, because he have the right to retrench, but he must make sure that he follow the law on this, okay. Then day off. Then now we see employer can retrench, okay, but before he retrench, he can also practice layoff. Okay, so what is layoff? Layoff is like temporary closing down the business, but under the law, okay, it means, okay, failure to provide work. That means the employer cannot provide work to the employee, okay, for at least 12 normal working days. Okay, in a month, no work for 12 days. Okay, the 12 days is in 4 consecutive weeks. That means it can be like 1 month. In 1 month, 12 days, no work and no salary without any remuneration, no salary. Okay, that means in total, you'll be working about maybe 17 days like that. Or if you minus the rest day, it will be even less. But you'll be employed with the employer. Okay, you will enjoy the EPF, you will enjoy SOCSO, everything. Okay, but only that you have less working days and less pay. Okay, so this can be done, but normally when is the situation is where the employer cannot avoid the retrenchment, got no choice. Okay, so he can try to like reduce the working days so that his business still going on, and the employee will not lose the job and will not go somewhere else to find a job or leave the company. Okay. Okay, so the employer, okay, have to also follow the procedure under the Employment Act, okay, where the employer must report to the nearest labour department at least 1 month before the retrenchment. That means the labour department must know, okay, that certain which company were going to retrench the employees, because this is where the labour officer also have a role to play, where they will help the employee from one company, okay, to get a job for another company. Okay, so they know which company retrench. Okay, so they will help the employers, okay, to find workers or employees if they need. So if you fail as an employer, if you fail to inform the labour office, so it's an offence under Section 63 and also 99A. Okay, any question? So you know that employer also have responsibility under the Employment Act. Okay. Okay. Now, how are you going to select the employee? Okay. So you know that you cannot avoid retrenchment, and you have to choose the employee. Who are you going to choose? It's very difficult, because um, when you choose the wrong person, the employee will get angry and he will sue the company. Okay, so here there's a criteria under the code. Okay, the code says that okay, um, the company can work together with the trade union. Okay, so they will see whether the employee is needed or not for the efficient operation of the company or not, or the business, his ability, his experience, skill, or occupational qualification. Okay, so you will consider all these before you want to terminate a particular employee, or you want to choose the particular employee. Okay, for it can be on the length of service, how long he had worked, his status as non-citizen, casual, temporary, permanent, his age, and also his family situation. So these are the selection how you want to choose the employee. Okay, you can follow this criteria because it's suggested under the code. Okay, then other than that, there's also a principle that we call as LIFO, last in, first out. That means it's a rule that under retrenchment, the employer have to follow. Okay, that means the junior employee, the last person join the company, must be retrenched because he's a very junior employee. Okay, so if the employer not want to use this principle, he must give sound reason or valid reason why he do not want to use this principle. So this is a golden principle in retrenchment procedure. Okay, LIFO. Okay, and we got cases on this. Okay, so that is to say that okay, in Ganda Plum services in Bahad. So if the employer do not want to follow the procedure under LIFO, so he have to give a valid or sound reason why he want to depart. Okay. Then foreign employee, as mentioned in the code also, there's a provision in section 60N Employment Act. Okay. the employer must retrench the foreign workers first. Okay, if they are employed in the same category, same capacity, that means same job, okay, job same specification, then only you can retrench, okay, the foreign employee. Okay, so maybe you have heard about VSS. VSS is a voluntary separation scheme. Okay, so the employer want to separate from the employee. Okay, want to terminate the relationship between the employer and the employee. Okay, but you want to do it with voluntarily. Okay, so you can see many companies are introducing this scheme. Sometimes it's known as mature because both parties agree to the separation, employer and employee. Okay, so the employer will prepare a package to give as a compensation. Okay. So the amount of compensation actually depends on the financial capability of the company. Okay, so big companies, of course, they will give very good compensation. Small company will give whatever they can afford. Okay, and under the law, there's an Employment Act. There's also one regulation for the termination and layoff. Okay, where can be used for a retrenchment purpose also. The amount of compensation is mentioned in clause 6.1 of the employment termination layoff benefit. Okay, so you must know that Employment Act only applies only to the employee within the definition of the Employment Act. That means your salary must be below 2,000. Okay, so you can see here the amount of compensation. That if you're working less than 2 years, you get only your compensation is 10 days for each year. Okay, that means 2 years as working, you get 20 days of salary. Yeah? Okay, if you're working 2 to 5 years, you get 15 days for each year. Okay, that means 5 years times 15. Okay, that means you get around 75 days of salary lah. Okay, or if you're employed more than 5 years, you get 20 days salary, 20 days salary for each year. That means 100 days of your salary. Okay, that means about 3 months over salary. Okay, so this is the, we can say it's very minimum. Okay, very little compensation. Okay, so beside that, if the company have trade union, they can also have provision to pay compensation under the collective agreement. So you will study collective agreement later, how it binds the company and also the employees. Okay, so again, section 30, subsection 5A provides that the court must take into consideration the agreement or code relating to employment. Okay, so if the company have the trade union have collective agreement, so it's better to prepare a good compensation scheme to the employees. Okay, so case Golden Plus Granat Sdn Bhd had that the company have done in contrary and not in accordance to Article 29 of the collective agreement. So the court ordered the company to reinstate 4 employees in their former position without any loss of service, seniority, wages, any other benefit, monetary or otherwise. Okay, so the employer must follow the collective agreement. Okay, if not, when the matter goes to the court, the court can order the company to comply the collective agreement. Okay, so before retrenchment, okay, the employer also have to give notice. So we have learned about the notice before this. The length of the notice is as specified in section 12 subsection 2. Okay, so it also depends how long you have worked with the employer, that less than 2 years, 4 weeks notice, 2 to 5 years employed, 6 week notice, or if you're employed more than 5 years, the employer have to give 6 weeks notice to the employees. Okay. Okay, so if the employee is not satisfied, okay, so he can bring the matter to the industrial court under section 20. Okay, so the court will decide whether the dismissal is fair or not. Okay, whether there's a redundancy or not. Okay, so it's a matter for the court to decide. Okay, so in Colgate Palmolive Sundaram Berhad, the court had that a worker's complaint consists of two elements. First is that he has been dismissed, and secondly, whether the dismissal was without just cause or excuse. Okay, so if you can prove that you've been dismissed, but there's no reason for the employer to dismiss, it will be unfair dismissal. Okay, so that's on redundancy. So that's all for redundancy today. Okay, so do you have any question?
No, madam.
So you can understand, okay, so how employer who already engage you, okay, or take you to the employment, okay, enter into contract with you, later he can also terminate your service, okay, because of surplus of labor, but he have to prove there's a really surplus of labor, okay, and he have to follow the procedures under the code, okay. Then he have to pay compensation. He also have to give notice, okay. So if you can prove that um, uh, the employer have victimized you, okay, that means he said there's a surplus of labor, but after a month, okay, you came to know that he what do you call, he employed another employee in your position. Okay, if you can prove that, you can say that the employer have actually not he has not acted bona fide because he later took someone to replace your position. Okay, so he cannot do so. He must prove that your position is actually redundant. He do not need you in that particular position. Okay, your position will be redundant. Okay, any question? No. Okay. I give a break about um, um, 2 minutes. Okay, come back. Okay, to talk about the assignment. Okay, just 2 or 3 minutes. Break for a while. Okay, students.
Okay, madam.
Okay,
Okay, madam.
Okay, madam. Dictate.
seen the assignments? No, sorry for the notice on the assignment one.
Yes,
Yes.
madam.
Yes, madam.
Uh-huh.
Yes, Doctor. Let me see.
So I want to know whether you already got the groups, members of the group.
Yes, madam.
So
Yes, madam.
okay, so what you do after this class is that you have your leader, okay? The leader is the one who will consult me, because if there's so many, I don't know which group you are. So whenever you WhatsApp me on the assignment, okay, I will not give you the answer. Okay, if you are not clear about something, you can ask me, but no answer for me. I will not, because everything is assignment, and just one test and one quiz is like 100%. So we give everyone the same question. Okay, so I cannot give you answer. Okay, so if you got any doubt, or you are not anything to do, but not the answer, okay, you can WhatsApp me, okay, and you inform me which group you are. Okay, so for the group, I want you all to in the WhatsApp, okay, you have to give one list, and not everyone send me the name with the group, okay. Only the leader will send me the group member's name, okay, with the metric number, okay, and you identify your group with color, okay. Do you want color or name of the flower? Which one do you want? You want color, or you want like red, blue, green? I don't want 1, 2, 3. I don't want it. You want color, red, blue, green, or you want with name of flower? Okay, like you want orchid, you want hibiscus, or maybe whatever. I think with color, everybody wants.
Color.
Okay, so okay, okay. So the group, you can choose your own color, what color you want. So you WhatsApp to me, okay? Your group color with the member's name. Okay, so everyone got the same question in the website, in the online, okay, portal, okay, and you have to answer, and also do not like name the case only without facts and decisions. So support with a latest case or very good cases. Okay, do not just copy from any textbook and put the facts of the case like that. I want you all to search properly the facts of the case and section, okay, and answer the question properly. Okay, so limit, if possible. I think I put them. I'm not sure 15 pages like that, but limit if possible less than that. Okay, if possible make it 10 pages. I think is enough. Okay, I'm not sure how many pages actually I put, because not have to open and see again. So if possible make it 10 pages. Okay, then make sure everyone gets your own the group. You got your group, you got your leader and the group. Okay, because individual assignment cannot be sent. Okay, so you cannot send individually saying that you don't have a group. So make sure that everyone have a group. You got how many members in a group?
6, madam.
6. Okay, that means one group will have 5, because it's 59 students. Okay, one group will got 5. Okay, the other group, 9 group will have 6, and the last group will have 5. Okay, yeah, 54 plus 5, 59. Okay, so question for assignment 2 is already ready. Okay, so you can see the deadlines. So don't wait until the last day to send. Okay, because the assignment 2 will be given very soon, and the date will be early January. Okay, so the deadline for assignment 2 and 3 is not that I mean, the time period is not very long, because you got another assignment, assignment number 3. Okay, remember that. You got assignment number 3 also. Okay, there's 3 assignments. We have not prepared yet the 3rd assignment yet. Okay, so then you will have your quiz also. So when you got to work, immediately do it. Do not wait until the last moment. You have to, I think for different courses, you've got different assignment to do. Okay, so make sure that you make an arrangement with the members and then proceed to do the assignments. Okay, so any question?
Madam,
Yeah.
you said that you won't give us answer, right?
Yeah, I will not give any answer, only maybe regarding format or you are not sure about something, okay, but not the answer. Okay.
Madam, what about if we submit you a draft? Can you check it for us?
It normally I can advise but not on the answer. Okay, unless I can give you a like general answer, say okay, your answer is totally wrong. That means please discuss again with the member.
Okay. General answer is okay with us.
Uh-huh. Okay, general, not specific. Like under section what, I cannot give like that. Okay. Maybe you referred to the wrong act, but there's only 2 act there so far. Okay. I will see how much I can advise you, but not to give straightforward answer because everyone got the same question. Every group got the same question. Okay.
Okay, thank you,
Okay.
madam.
Any other question? So please send the members' name. The leader will WhatsApp to me. Okay, but you can put in the group WhatsApp no mind. Okay. Then with the color that you choose. Okay, because you will be given one more assignment, and the 3rd assignment will be during the will be also soon. Okay. Okay, so if there's no question, okay, I think I will stop here today. Okay, students, can I stop?
Can.
Yes,
Madam.
madam.
Yeah, okay. Thank you, everyone. So I'll be seeing you next week.
Thank you, madam.
Thank you,
You're
madam.
welcome.
Madam.
Okay, bye.
Thank you, madam. Assalamualaikum.